Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's vlog I'm going to be talking about dyslexia because it's Dyslexia Awareness Week. I've actually been asked by the Law Society to speak on the radio a number of times this week about the topic, so I thought it would make sense to put the same information into a blog. I have been looking at the NHS definition of what dyslexia means to see how they explain it, and they reference it as a learning difficulty in relation to reading, writing and spelling, but they're at pains to make clear that we're not talking about anyone having impaired intelligence. It's just that they do struggle with those things. Now, like lots of medical conditions, when you're labelled as having that particular condition, you're diagnosed, the way in which it affects you is likely to be unique and different to how that condition might affect somebody else. So we've always got to be really careful when we're talking to people about their dyslexia, that we focus on how it affects them and we don't come to that conversation with assumptions that we've made about how it affects somebody else that we might know with the condition or another employee that we might have been dealing with, because everybody will be different. Dyslexia can also be linked to other medical conditions, so dyscalculia, which is struggling with numbers. Attention deficit disorder may be present, also dyspraxia, which relates to coordination. So we do have to take each individual case on a case-by-case basis and deal with it that way. In terms of discrimination law and how that fits in with the subject, the Equality Act 2010 enables somebody with a disability to bring claims in a number of different circumstances. Now, a disability is defined as a physical or mental condition that's long-term, and dyslexia will be, that has a significant effect on the person's ability to carry out normal day-to-day activities. And that's likely to be the case with dyslexia, so it's likely to be covered by the legislation, so somebody might be able to bring a claim in one of the following circumstances. So the first circumstance would be a claim of direct discrimination, and the best example of this is to say, but for my dyslexia, I would not have received the treatment that I had. So I might be viewed by you as an employee as somebody who might struggle to go on a particular training course because of the work involved. So you might make that judgment that I wouldn't be up to it, and you decide not to send me on the course. I then claim that that's an act of direct dyslexia discrimination, because if I hadn't had the dyslexia, then I could have got on the course, and you are unable to then defend that claim and are likely to be liable to me for that. Indirect discrimination will be the next kind of discrimination that I might claim. That's where you apply the same policy or procedure to everybody, but I say it affects me more negatively, if you like, as a result of my dyslexia. So for example, you might have a promotion process and that might involve me having to fill in a form, and I might say that puts me at a disadvantage compared to somebody who doesn't have dyslexia. I'm going to struggle with that a bit more, particularly perhaps if it was having to be done in timed conditions or something like that. So I will then argue that that's indirect discrimination, and you will have the opportunity as the employer to justify your particular policy or procedure that you've put in place, For example, you may be able to show that you've got a legitimate interest in working out who is best to promote, and that you've gone about doing that in a proportionate manner. And there's often a link there between that proportionality test and whether or not you've taken reasonable adjustments, which we'll come on to talk about in a moment. Harassment might be another form of claim that somebody might bring. So colleagues might tease me about my dyslexia or that I'm very slow at doing something. There might be banter. They may say things, do things that make me feel there's a hostile working environment. I've been subject to intimidating behaviours. I would be able to claim harassment, and potentially you as the employer could be liable for that if you haven't done everything that's reasonable to prevent that from happening. For example, providing training to people. Fourth kind of discrimination might be victimisation. So where I've already brought a complaint about one of the other things, so let's say harassment, and then because I've challenged about that, you might refuse to give me a reference. That would be an example of victimisation. Section 15 of the Equality Act is a kind of growth area at the moment, and this is discrimination arising from a disability. So you may feel that you're dealing with my conduct. So there's a classic case in Starbucks where a lady had to do checks every so often for hygiene reasons and complete certain paperwork. She hadn't done that, so she was subject to a disciplinary process. She was dyslexic. She will argue that behind that conduct, if you take sort of a one step back from it, is her disability, and the reason why she wasn't doing the paperwork was her dyslexia. Another example might be performance management. You might be criticising me for not having hit my targets, for not having completed something on time, and I may be able to argue that behind that delay is my disability. So whenever we are managing somebody's performance, conduct, sickness, absence, if it's an absence issue, we do need to take that one step behind approach and ask ourselves, is the concern that we are addressing here actually linked to the disability? If it is, we probably need to be getting some medical advice about that before we make any disciplinary judgments or decide how to follow any of our policies, etc. Again, that's something that the employer may well be able to justify if they are pursuing a legitimate aim, such as managing performance. But again, there's often that link with reasonable adjustments, which is the last kind of discrimination I want to talk about. There is a duty on the employer, once they know that somebody is dyslexic, to take steps to level the playing field and remove the substantial disadvantage that that condition puts them at. And it's very important to get some advice, get the British Dyslexic Institute in, some of the charitable associations that can support in this area to assist you with assessing the individual, as I've talked about earlier, and their specific needs and what they may need. And we might be talking about things that are relatively easy to do, but what might work for one person wouldn't necessarily be right for another. So one employee might find that printing things out on yellow paper really helps them, but for another employee, they might find that a different font or a different colour assists them. So it does have to be on a case-by-case basis. The other thing that I find employers don't do terribly well is keep on assessing. So they might, when they find out somebody's got a medical condition, make a lot of adjustments. What they then forget to do is later on, 2, 3, 4 years down the line, when everybody's kind of forgotten about it because perhaps it's become normal that that person works in a particular way and we do all those things for them, and we do something new, like, I don't know, a redundancy process. Do we forget then to ask ourselves about reasonable adjustments at that point in time. Those are the sort of key areas that will come up in any particular situation. One of the things that I often get asked is, are we allowed to ask the employee if they've got this condition? Or from the employee, do I tell the employer I've got this condition? Well, there's no obligation on the employee to tell the employer. So the employer can't get upset that somebody hasn't told them about the condition. When they do tell them about the condition, then that's when the duty to make reasonable adjustments is going to kick in, because you can only make the reasonable adjustments when you know about the condition. So Section 60 of the Equality Act bans an employer from asking medical questions on recruitment, except there's a bit of a coach and horses that goes through that provision, in that if it's intrinsic to the nature of the job that you need to ask the question, then you can. So, for example, if somebody was to come and work for me as a solicitor, obviously I have to process a lot of documentation and information in a very, very quick amount of time, and assimilate all of that and make decisions on it very quickly for clients. It would be legitimate for me to ask somebody, to set out what the job involves, and then to ask somebody if they had any specific concerns about them being able to work in that way. It wouldn't necessarily be fair for another kind of employer doing something entirely different to ask that question. So we've had a very quick gallop through the state of the sort of legal position on this subject. I would encourage employers to take advice, do work with some of the charities. There is government funding floating around. So Access to Work is the government body that can fund adjustments. I've had an example recently of an employee who struggled with map reading and finding their way using road signs, etc. So Access to Work were prepared to pay for taxis for that person to be able to go out and still do their client face-to-face meetings. Another example might be paying for somebody to go on a particular course that they need. So an employer needn't be put off by the fact that all of these adjustments are going to be complicated and cost them lots of money. Often they're relatively straightforward things that need to be done and that don't cost a lot of money, or if they do, we can get some financial support for it. So the key things are, don't make assumptions, actually talk to the person themselves and find out what help they would benefit from. They are the ones who will know themselves best, and they will know how they like to operate and work. So let's work in dialogue with them, and let's not get ourselves into hot water needlessly by forgetting our legal duties. If you have got any questions, adenton@refreshinglawltd.co.uk. Don't leave questions on YouTube because I never get to answer them. You'd have to contact me directly. Thank you very much.